The judge said to trespass someone from a public space, 2 distinct and clear communications were needed. The first revoking the right of the authority to be in a public space and a warning. The second is a warning that if they remain they will breach the Trespass Act. Police error sinks Parliament protesters' trespass charge, exposing loophole. The first legal challenge to the validity trespass orders given to Parliament protesters early in the occupation in February has won for those arrested. Muar Marker, from Palmerston North, had pleaded not guilty to a single charge of willful trespass. The charge against her was dismissed on Friday by Wellington District Court Judge Andrew Nichols, who said the police's communication with those on Parliament grounds had not been clear enough. The decision has repercussions for others arrested on February the 10th between 8:25 a.m. to 9:10 a.m. About 120 people were taken into custody on that day, with police confirming 31 prosecutions are still active. Marker was on the front line when police began using loud-hailers to broadcast to leave the grounds. Speaker Trevor Mallard had ordered the grounds closed and everyone who did not leave to be trespassed. Judge Nichols was asked to decide if Marker had breached the Trespass Act by not leaving the grounds within a reasonable time after receiving the warning. Between February the 9th and March the 4th, 2 people were arrested. More than 40% of prosecutions have already been withdrawn. The judge said to trespass someone from a public space, 2 distinct and clear communications were needed. The first revoking the right of the authority to be in a public space and a warning. The second is a warning that if they remain they will breach the Trespass Act. The judge said after February the 8th, there was a sudden escalation of the number of people and structures on the grounds, and at a meeting Mallard authorized the police to close the grounds. On February the 10th, police began reading out messages over a loud-hailer requiring all tents and structures to be removed and if they were not, for the grounds to be closed. The message included that any person remaining following the grounds being closed would be trespassing and risked being arrested. Police gave 15 minutes for people to begin moving, and when they did not said Parliament grounds were now closed. Judge Nichols said by then a confrontation between the police line and protesters had formed at the northern end of the grounds. Marker was arrested at the skirmish line at the northern end of the grounds at 8:47 a.m. She was sitting on the ground at the front of the line. The judge said arrest teams would reach through the police line and pull protesters through. From this narrative it is clear that parliamentary services and police attempted an escalating series of messages to the protesters over the 3 days to encourage compliance, from least confrontational through to closing Parliament grounds. He said in his view the first message read was not a clear revocation of the authority of people to be on Parliament grounds sufficient for it to be a warning under the Trespass Act. It was an escalation of the messages that had already been given. Judge Nichols said the language used was a last request to leave, but not a revocation of the authority to be on a public place. He said from 8:25 a.m. until about 9:10 a.m. on February the 10th police were broadcasting 2 different and inconsistent messages. The first was a final request to remove the camp or the grounds would be shut, and the second was that the grounds were closed and there was a risk of arrest. The second of those messages was a warning under the Trespass Act, the first was not. He said because Marker was arrested during the period when the police were delivering inconsistent messages there was reasonable doubt whether it had the required clarity. Another vaccine protester won his case against the trespass order when police withdrew the charge last month. Associate Professor at Victoria University of Wellington Dr. Dean Knight, who specializes in public law, said the ruling appeared quite narrow in application and related only to the particular way the occupation was managed in the early days and, then, for a period of less than an hour. Police said in statement on Friday the decision would be reviewed.